Let me bring in my guests now. Sandeep Parekh is a corporate lawyer. Sumitra Goenka is a political analyst. We also have Tushar Gupta, political analyst. Beginning with you, Sandeep Parekh, it's about the small investors. It's about their interest which has to be protected. And what is becoming clear is that the Supreme Court had ordered the centre and SEBI to use the committee's suggestion, which the committee had suggested. There are need to strengthen the investors.
Yes.
Yes.
I think to summarize, I think the committee report which had come out some time back had brought in certain suggestions with respect to how to strengthen the enforcement capabilities of SEBI, and it's quite detailed. And I think Supreme Court has essentially asked both the government and SEBI to review those suggestions made by the committee and implement them if possible. In terms of, I think the focus has been on investor protection, and it's not just, any investor, but including investors of Adani, because if the Supreme Court also says that, to the extent that there's any mischief by short sellers, that also needs to be probed by SEBI. So I think overall, I think it's a good ruling. It basically kind of gives primacy and deference to SEBI as a regulator, and they clearly say that any newspaper reports, all these other reports can be an input. They cannot be the conclusion.
Think that rejection of the reports, the OCCRP which followed Hindenburg, Tushar, becomes important here, because the court goes on to say that there is no evidence to believe that whatever they published was correct, and there are no grounds to transfer this probe, in this case from SEBI to a Supreme Court appointed SIT.
Good evening, good afternoon, Maria. Yes, absolutely. I think that's what everyone has been saying for the longest period of time now, that a third-party report, essentially those who have been defined as short sellers, they cannot be held as the gospel truth. While the political opposition may want to use it as a tool to attack the government, or attack the capitalists, or attack the Prime Minister, it doesn't take away from the fact that it was published by a third party. It was a short seller report, and there was a lot of political references also made in that report, which sort of made the opposition demand the need for an SIT, which would never have happened. From a regulatory point of view, of course, it makes perfect sense that these things can be only an input. They cannot be a source or a reason for an SIT to be ordered. But look at the political side of it also. In February 2023, in early February 2023, when this report came out, the opposition started questioning the solvency of institutions like LIC and SBI, panicking investors, and questioning the entire India growth story. That is something that shouldn't have happened. This was at the end a third-party reports. Several such reports will come. Several such reports will inflate the value of a company or probably deflate the value of a company, depending on who writes them. But then they cannot be the gospel truth either for the investor or for the regulatory bodies or for the courts.
Okay, we have Saket Misra also joining us. Saket, thank you so much for your time. As an investment banker, as an economist, how are you looking at today's judgment?
Well, I think it's a very good judgment, Maria. Good morning first to good afternoon. I think it's a good judgment because it clearly sets in place who should be doing what. So I think the role of SEBI has been very clearly defined. It also sets in place some potential for improvement in our regulatory regime. So some of the ideas that have come forward in the report, in this committee report, have also the SEBI has been asked to look at those. And I think the other piece that some of the previous panelists have referred to, speculations and somebody accusing another person of wrongdoing cannot merely be a cause for action. And I think that's very important. And linked to that is the fact that every time someone makes a loss or the stock market falls, that also cannot be the source of action for people to start investigating. So I think it's laid down the law, and more importantly, it has strengthened the sanctity of institutions like SEBI, which have a particular role to do, which actually do market. I mean, I know for certain that SEBI and every other regulator looks at large trades in particular counters. It looks at when these trades happen, whether they happen before announcements, after announcements. So they are actually pretty sophisticated regulators. And what the court has said is go ahead and do your job freely and without any bias. So I think it's a good judgment.
Okay. Sumitra Goenka, come in on this. I think what the Supreme Court has said, particularly with regards to these external reports, saying that these reports come out without any proof and they cannot be themselves seen as evidence to transfer what has been given a clean chit by SEBI to another investigating group, which is the SIT. So I think it's essentially backing the SEBI clean chit which was given to Adani Group.
Yeah, so good afternoon, Maria. I think it emphasizes the fact that we have very strong regulatory bodies in place, be it the SEBI or be it the RBI when it comes to the banking regulation. Supreme Court very
Okay,
clearly
we'll try and fix your line, Sumitra, but I think the powers that are there with the SEBI is something that the Supreme Court has also asserted. Would you agree with me, Sanjay Singh, on that? That Supreme Court has given clean chit. Why should there be an SIT probe to look into what the Supreme Court clean chit has been?
Maria, with this petition, the petitioners had tried, Shant Bhushan in particular, and whosoever had published those reports, Hindenburg and thereafter OCCRP, that besides an attack on Adani Group and the political system out here, there was also an attack on to raise questions on our institutions, regulatory mechanism, regulatory institutions. Supreme Court, sorry, there is some disturbance.
No, we are trying to fix that, Sanjay. Go ahead.
The Supreme Court's constituted committee, led by a former Supreme Court judge, and also very eminent persons with high credibility.
Hello, can you hear me?
They had kind of then concluded that there was no regulatory failure on part of any regulatory institutions. So that attack, the Supreme Court has rejected through this petitioner's intervention, and Supreme Court has maintained that these institutions, I'm paraphrasing that, are credible and they know how to do their job, and they're doing their job in this particular case also. And therefore, there was no reason to intervene and ask for a SIT probe. Supreme Court has even gone further that all petitions and third-party reliance, anything published abroad, as we know as of now, that for past some time has happened in, if you look at Rafael case, Pegasus case, this particular case.
Yes, because if you remember what happened last time around on 24th of November, at that time, the Supreme Court had said very clearly, I remember what Chief Justice of India, Justice Chandrachud, had asked the petitioner's lawyer, Prashant Bhushan, why must we take foreign reports as truth? What proof do you have against the Adani Group? It has gone on to say that we are not rejecting, but we need proof. So those are the questions that were asked. And of course, they had said that where is truth and can that be seen as gospel truth? So Sandeep Parekh, this will ensure that such petitions which are filed in future, which the Supreme Court says it lacks research, it lacks any basis and evidence.
1, 2, 3,
so
4, 5,
these
6,
petitions are not filed and they are dismissed in the very first hearing. Sandeep?
Truth about India, we are.
Yes.
Can you hear me?
Yes, I can hear you.
Yeah, so I think we are a litigious society. So I think it will set a precedent.
Yes.
But at the same time, people do kind of end up filing all these PRs, etc. So I think this ruling is not going to stop future, actions similar to this. At least it puts a quietus on this matter, and it takes the football back to SEBI, and I think they found SEBI to be doing a fair job of the matter.
So I think that's the correct assessment. I would say it's about SEBI doing its job well, Saket, and that's what has been asserted by the Supreme Court.
Thank you, Maria. And again, I think there is also a lot of good that comes out of this, because people say that you shine light on particular dark corners and that sanitizes things. So I think a lot of improvement will come as a result of this, because I'm sure SEBI will get some good ideas from it. I'm sure people who had doubts will clearly realize that there is a process to be followed. There is a burden of proof that needs to be met. So I think it sets a lot of standards. And I dare say for overall corporate governance in India, it will be a good thing, because I reckon people will also now take greater care to ensure that there is no doubt and there is greater communication, etc., with stakeholders when they take large capital markets transactions. So, to my mind, and this is very important for international investors, the fact that SEBI has been allowed to do their job and to do their job in a professional, independent manner is very important, because that's what most investors look for: a regulator that knows what they're doing and that is allowed to do what it's doing.
Yes, and what exactly had SEBI said? Would you recap that for our viewers, Saket?
I mean, SEBI has basically said that as of now, they will. They didn't find, again, if I recall correctly, they didn't find any
Wrongdoing.
any wrongdoing in the entire exercise, and I think they expressed an openness to undertake the full investigation, which is what the Supreme Court has said, and to tighten regulations. So I think some of the steps they're taking, for instance, about having companies answer to market speculation or clarify market speculation, those are good things that are coming out as a result of this.
So what Supreme Court has said, that short seller Hindenburg should be investigated as well. Ke khilaf jaanch kare. That's what it has said, and there should be action that should be taken against it as well. What kind of action can be taken? Tushar?
Well, look, at the end, Hindenburg is not an Indian entity, not it's basing its operations out of India, so it's hard to say what action can be taken. But more importantly, it upholds the credibility of the regulatory organizations, not just their purview, but also the credibility which was being questioned in all this political bickering that has lasted over a year. One has to understand that Hindenburg people confused it perhaps for a regulatory institution or for some sort of a credit ratings body just for their political benefit. But at the end, it was a group of short sellers. We need to understand this. The political opposition needs to understand this. So the action, again, it's up to the government how they take this up, maybe diplomatically, maybe through other channels. That's up to the government to decide. But for the people, for the investors in the market, they shouldn't be swayed by the political bickering when it comes to the market, and that has been the case now lately. I don't think after February, Adani suffered any setback in the markits. The people also saw for what the Hindenburg report was.
In fact, they regained their market cap.
The investors have reimposed their faith in the Adani stocks. They have
I want to understand from you, Sumitra, because Hindenburg, after the Hindenburg report, the investors, the small investors in particular, had lost 4 lakh crore. What measures should be taken to ensure that there are no such short sellers who have their way by publishing malicious reports against companies?
Yeah, so Maria, can you hear me now?
Loud and clear, please go ahead.
Hiya. So initially I was just making one point that the Supreme Court has clearly said that there is absolute trust on the regulatory bodies, be it like SEBI in this case, and also our Indian regulatory structure is very well thought out, and I think so that is one of the important things we have to understand here. Secondly, coming to the investors part of it, see Dalal Street, when you look at Dalal Street, it has seen phenomenal growth in the last 1 year. Yes. It is now the fifth biggest after Hong Kong, and at least 3.8% of the global market capitalization share now lies with India. So you can imagine the kind of investments which has come in the last year alone, which is totaling to around 900 billion US dollars, or 53,000 crores was raised in the primary market. So any such thing, any such report which is unsubstantiated or which is not supported with proper facts, it can cause havoc in the market, like we saw in the case of this Adani thing. Adani Group has in fact prepaid loans worth rupees 2.65 billion in the last 1 year, even after that report has come in. So there was nothing wrong with Adani's, but the kind of report which was generated caused all these issues. But I think one is there will be always some repercussions in the market, because market is very much sentiment based, and any such news can cause ripples in the market. But what steps can be taken is this particular judgment itself is going to give a lot of confidence, and investors will also learn not to believe on such reports which come out from outside sources. And what we saw again, secondly, was probably this report was a part of the toolkit gang, because there was noise in the parliament, outside the parliament, and also with unconfirmed media reports coming in. So I think Adani is also, I don't know, but I think they should, take some action against the people, especially the media companies also, who have put in such reports which were unsubstantiated.
Sumitra, if you look at what Justice Chandrachud, CJI of India, has said, referring particularly to this OCCRP report, he said that the reliance on OCCRP report is rejected, and the reliance on the third party organization report without any verification cannot be used as proof. It goes on to say there are no grounds to transfer the probe in this case from SEBI.